Good morning. My name is Malcolm Neekirk. Welcome to Threaten's third coffee break briefing of 2024. I can't believe it's already March. Still, at least winter is almost over and we should be seeing green shoots and to cheer us up in the next few days. Now, before we get started properly, I've got a question for you, if I may. As you're here, I guess you have at least a casual interest in MVLs, and I know that some of you are MVL specialists. So my question is whether something like this has ever happened on one of your cases. There's a liquidator I know who picked up a fine from Companies House the other day. Of course, it wasn't his fine, it was addressed to the company. But let me tell you what triggered it. The company was late filing its accounts. They had prepared them for the MVL, but I guess there was a rush to get the company into MVL as well as to have the accounts prepared. So the accounts weren't actually filed until very shortly after the MVL had opened. Normal procedure for Companies House, of course, is that although there's still the statutory obligation on companies to file accounts and confirmation statements, it's not enforced by Companies House once the company is in liquidation or any other insolvency procedure. But despite that, in this particular case, despite the company being in an MVL, Companies House imposed its normal late filing fine. So my question is, have you ever had Companies House fine one of your liquidations? If you have, please drop me a note through the chat box or on an email, and I'll perhaps pick it up with you at the end. Now, with all the briefings that we've got planned over the course of this year, you will, of course, be able to log nearly 6 hours of verifiable CPD if you join me for all of the coffee break briefings. And remember, if you do miss one, they are all recorded, so you will have an opportunity to catch it later, or indeed colleagues of yours who might find it useful can see the video recording as well. And as I always do at this stage, I will remind you again to try out the retention of title website tool I showed you last year. So if you're interested, why not scribble down a quick note to yourself to have a look at it at the end of this morning's presentation. You can find it by Googling Threaten's retention of title, or you can drop me an email and I'll send you a link to it. And also remind you that I do evaluations in administration pre-pack sales, and I'll be very happy to give your buyer an estimate if you are selling to a connected party soon after your appointment. Okay, so that is all of the housekeeping out of the way. So I will now start the presentation itself. So welcome. Today's topic is tax clearance in solvent liquidations, and more specifically, how to deal with a solvent liquidation where there is no tax clearance. There are 4 topics within that I'm intending to cover. First of all, what just happened, look back over the recent history and why it is that I'm making this presentation. Secondly, why was it that liquidators usually asked for clearance in any event? Thirdly, then, I'll be looking at what the options are for solvent liquidations now that you're not going to get clearance. And I'm going to finish off then by looking at some of the points to look out for, some of the perhaps strategic decisions that you may need to make for your practice about the way that you deal with MVLs in the future. So let's look at the brief history behind this. And without going into this in too much detail, it seems fairly clear that this was an issue where, as in so many areas of the public services, HMRC were under-resourced and overworked in terms of the commitments they had to deal with. And it was apparent over a period of time that it was becoming increasingly difficult for them to deal with clearance requests in a reasonable time frame. And this then culminated in the 6th of December with a decision by them that they would no longer issue any clearance to any liquidators or indeed other insolvency procedures. And that was a change in policy with immediate effect. So those old MVLs that you've got where you've been waiting perhaps 18 months or more for a clearance request, you're never going to get it. So you just need to get on and close that MVL now without waiting any more time for clearance that's not going to come through. This slide basically shows the history leading up to that decision and the increasing difficulty that HMRC had in coping with clearance requests and some of the steps that they had made to try and alleviate the strain themselves. So let's look at why it is that you would ask for clearance in the first place. Now, if we go back to the announcement that HMRC issued early in December last year, that very helpfully summarized all of the statutory basis for asking for clearance and indeed the case law and other best guidance that had been issued that the whole procedure was based upon. And in the next slide, I'm just going to unpack that and look at that in a bit of detail. Yep, there's absolutely no legal basis whatsoever behind HMRC granting clearance. It was one of those things that just grew up through custom and practice, and it happened because liquidators had always been asking for clearance and HMRC had always obliged. So why was it that liquidators did ask for clearance? Well, the truth is they didn't always do so, and it was not that unusual to close MVLs without tax clearance, particularly long-running MVLs that had been going for a great deal of time and where it did seem to be taking an inordinately long time to get clearance. Clearance, of course, would give you comfort that HMRC had no live issues and that having distributed the assets, you were not now going to get a claim from HMRC that was going to take years and years to deal with or that was going to result in an expensive tax bill. But clearance didn't always mean that, and you found that actually there were quite a few false positives with clearance, situations where HMRC had granted clearance and then realized that the assumptions on which they had granted clearance were not true. There were issues they didn't know about when they granted the clearance that they now wanted to reopen. And the clearance was usually heavily caveated so that HMRC would reserve themselves the right to reopen anything that did need proper investigation. The thing was, you always knew that there was an issue if they came back and said, no, you're not going to get clearance. But that didn't happen terribly often. And it could be a very long wait for that clearance to come through. And from what I've heard, I think many practitioners found that they would be waiting perhaps 18 months on many of their cases, which of course raises the question as to whether we might even be better off without having a clearance procedure, and we may be able to close MVLs faster and more efficiently as a result. So let's look now at what you should be doing instead of asking for clearance. And I think there are three phases to the liquidation that you need to think about. The first one is the pre-appointment phase, and you should be looking there at the investigations that you carry out into the company's contingent liabilities and potential tax liabilities. You'd perhaps be looking at the warranties and representations that you ask the company and its directors to give to you, and you might be looking at your use of indemnities, which you probably use at least occasionally at present, and you might be wanting to increase the use of the indemnities or use them differently in the future. That's the first phase, the pre-appointment one. The second phase is during the liquidation itself and your obligations to file returns as they become due and pay any tax as it becomes due during the liquidation. And then the third phase, which is the one that probably has generated the most interest and attention, is closing the liquidation itself and how to run the statutory procedures in the context of an absence of tax clearance. So let's look at each of those in turn. The first phase, the investigations that you should be carrying out before the liquidation opens. And this is, of course, about getting information from the directors and their accountant. And I think there are two parts to the information that you are collecting. The first one is the objective assessment of the information that you're getting. What is it actually telling you? What do you know about the company's tax affairs? The second part is the subjective assessment, and this is the old insolvency practitioner's gut feeling. And it's what we all do all the time. We work out how reliable the directors are, how good we think that they have actually been at dealing with the company's tax affairs, whether they've been well advised, whether they've tended to follow the advice that they've been given, how diligent and careful they've been generally. And I think that's an important part of the assessment as well, in terms of giving you some idea of what the potential risk might be of some unexpected tax liability bubbling up during the course of the liquidation. The sort of direct information that you'd be looking for, the objective assessment, will be looking at the quality of the accounting records that are delivered to you, the history of filing tax returns, whether they've all been filed on time when they should have been, the history of paying tax within the company, whether it's all been paid when it should have been, and whether there are any current or indeed any closed HMRC inquiries and how they have been dealt with. You'll be looking at whether HMRC has raised any assessments, and if so, whether those assessments are in any way still open, or whether they can be regarded as closed and a legitimate assessment of the tax that is due. You'll be looking at the elections and returns that have been filed and delivered to Companies House, when they've been done, what issues they covered. And you'll be talking to the directors and probably their accountant about any tax work that needs to be done, either before the company goes into liquidation or once the liquidation has started. Things like, for example, surrendering any group relief and taking the company out of any VAT group, sorts of examples that you might have there. So you'll be looking at collecting all of that sort of information to assess the risk and the issues and record them and decide how to deal with them in the liquidation. And as I said, that would include your subjective assessment of how reliable the directors and their accountant are likely to be, and possibly what sort of relationship you think they might have had with HMRC. I mentioned warranties and representations, and I don't know really how widespread this is across the insolvency profession, but I think it would make sense to ask the directors to sign a letter of representation as part of your engagement package. And this will be a letter in which the directors tell you, as a legally binding commitment to you, that to the best of their knowledge and belief, where they've actually made all appropriate inquiries, they are assuring you that the company's tax affairs are closed, with the exception being the open issues that would be disclosed in a list attached to the letter, so that they know what you know about the company's tax situation when the liquidation starts. And if it turns out that there are other issues that they have not disclosed to you that turn out to make the liquidation more expensive and difficult to deal with, you've then got this letter that you can go back to them on and explain that you took the job on the basis that the company's affairs were broadly clean, and this is something unexpected. I can see that there might be some directors who would find it difficult to sign a letter of that sort, particularly if they're not shareholders, and particularly if they see that there is a personal risk to them of giving a legally binding commitment of that sort, where their interest in the company perhaps doesn't warrant that. I'm not entirely sure how to deal with that, but I can't imagine that's going to be a particularly common problem. Another point that I mentioned is your use of indemnities. Different firms have different policies about indemnities and different types of indemnity that they use. What I think is the common use of an indemnity in a solvent liquidation is the case where there is an early distribution being made to shareholders, so that funds are being passed over to them very, very soon after your appointment, and that will be before you've had a chance to run the statutory procedures of asking creditors to prove their claims, before you've had a chance to assess the claims. You've got only very limited information about the possible creditors that the company might be dealing with. Now, I think shareholders might perceive that there is now a greater risk of calls on the indemnity, because where you're closing a liquidation without clearance, you haven't had that positive step from HMRC where they're telling you they've reviewed the records and they can't see anything in the records that gives them any issues that need to be dealt with. So there's perhaps a greater risk. You might be looking at using indemnities more often, but the risk for shareholders is that there's a potential moral hazard here for the taxman, in that modern indemnities seem to be quite open-ended in terms of their duration. It's very common to see indemnities that will last for sometimes many years after the liquidation has closed, even after the company has been dissolved. And the shareholders might see that there is a risk that HMRC will see the opportunity of presenting late claims even after the company has been dissolved, because they might think that there's a good chance that there will be an indemnity in the liquidation, and that if they make a claim, they may be able to make a claim through the indemnity to claw back money that has been distributed to the shareholders. So I think there's going to be a new negotiation about the balance in indemnities that we will start to see. Moving on to the second phase, which is during a liquidation, that's very straightforward. You, of course, will file your tax returns when they are due, and you will pay the tax that is due during the liquidation. The third phase is the one where there has been, say, a lot of attention, a lot of interest, and this is the procedure for closing the liquidation. And I think it is going to be really important from now on that you should close every MVL completely by the book. And what I mean by that is following the statutory procedure of advertising for claims. And the statutory procedure would involve you waiting at least 21 days for claims to come in before moving on to the next phase. And it would mean that you would have to pay the distribution to shareholders within 2 months of the last date for proving claims. The statutory procedure does allow you to reduce the proposed distribution if you need to provide against a claim that comes in which is difficult to assess, and it does actually give you the right also to postpone the distribution if there is a claim that comes in where the only sensible approach is to actually postpone the distribution to shareholders. The key thing is that if you follow the procedure by the book, you are personally protected as liquidator. because you've followed the statutory procedure, you've done your duty, and that means that it is then very, very difficult for anybody to claim that you are guilty of misfeasance. Misfeasance would be a failure to do your duty. You've done your duty, you should be in the clear. But the statutory procedure is intended only to protect the liquidator and not to protect the company. It is still possible for creditors to put late claims in against the company. They can present a winding up petition to put it into a compulsory liquidation if they need to, and they can restore the company if they need to do so once it has been dissolved. If you want more information about the statutory procedure and how it works as a refresher, I did actually cover it in some detail in a coffee break briefing on the 8th of August 2022. So that recording will still be available on the Frettons website if you want to have a refresher on that. So this is a diagram that shows the timetable for advertising for claims. So some point after your appointment, you would think that it would be appropriate to make a distribution, and you should tell the creditors that you know about you're doing that, and you should also gazette the proposed distribution. You have to set a last date for proving. The statutory minimum is 21 days, and I think a lot of liquidators think that where there is at least a theoretical risk of HMRC making a claim, 21 days is probably not long enough to give HMRC a decent chance to respond to this. So you might be looking at perhaps even several months rather than weeks as being the last date for proving that you notify to creditors and you publish in the Gazette. Once that last date for proving has passed, you have to assess the claims that come in and adjudicate on them within 14 days. You have to tell the creditors what your decision is, and they have then got a very tight statutory 21 days to appeal your decision to the court. And then after that last date for proving has passed, unless you've got grounds to suspend the distribution, you have to go on and make the distribution, and that should be within 2 months of the last date for proving. Once you've distributed everything, of course, you then move to close the liquidation, vacate office, get your release, and the company will be dissolved 3 months after that. Now, in terms of how you deal with claims, up until the last date for proving, if a claim comes in and it's good, you have to accept it. After the last date for proving, if a claim comes in, then regardless of whether it's good or not, you are not obliged to accept it. You have a discretion to do so, and how you exercise that discretion is perhaps a little bit more complicated in the future, where there is this risk of late tax claims coming in, for example. And I think this needs to circle back to your engagement letter and what you are telling the shareholders from the start of your appointment, that if a claim comes in after the last date for proving, you still have a discretion to accept it, and in some cases it will be sensible for you to accept it, and in some cases you might be having a dialogue with members about whether they wish to recapitalize the company to pay the claim by paying back some of the funds that have already been distributed to them, and in some cases you might be having to consider maybe even making a call on an indemnity to force a recapitalization of the company. So these really are how I suggest you deal with HMRC. I think you should list them as an unquantified creditor right at the start and treat them as having potential claims for £1. You would actually give them formal notice of the intended distribution, as well as gazetting the proposed distribution. And then, assuming that you don't hear from them, which will probably be the case in the majority of MVLs, you would then write to them within 14 days after the last date for proving to formally reject all and any claims they might have on the ground that they have failed to prove any claim, and you'll be telling them that they have got 21 days to appeal to the court. Now, you really don't want them appealing to the court in a rush, which is why I'm suggesting that you perhaps extend the duration of the last date for proving so that they do actually have a proper opportunity to come back and say, look, I'm sorry, but we think we do still have an open issue here. So let's move on now to the final point I want to cover, which is some of the strategic issues that you're going to be thinking about what to look out for. Now let's look at this from the perspective of HMRC. If they find themselves wanting to make a late claim, the options that they have got include presenting a winding up petition if the company has not yet been dissolved, or even restoring the company if it has been dissolved. And if there is an indemnity, then in many cases, that indemnity will still be binding on the members, and the new liquidator appointed on the restoration of the company may well have a right to claim on the indemnity. So again, you might want to look at some of the cases that you are now closing that you opened before the 6th of December and look at the indemnities and think about whether it would be appropriate to formally release the shareholders from any indemnity that they have given. HMRC might also be looking at secondary liability provisions to claim from third parties. Third parties might include you as the liquidator. That shouldn't be an issue if you follow the statutory procedure, because their normal ability for claiming would be misfeasance. If you've done your duty, there is no misfeasance. They might be looking at statutory provisions that allow them to claim from shareholders, from directors, or from other group companies, and this might include Insolvency Act claims that they have got, or another example would be under Schedule 13 of the Finance Act 2020, where there are some circumstances in which HMRC may make claims from the directors of an insolvent company. And I covered that in a coffee break briefing in December 2020. If you want a refresher on that, the video is still on our website. Now, suppose you have an MVL where HMRC does make a late claim, and suppose that there is some sort of liability that could flow through to the directors or the shareholders. They might be looking at whether you owed a duty of care to them or the company, either as pre-liquidation advisor or once appointed as liquidator. And this is where I think that you need to look at the advice that you perhaps gave about the risk of a late claim, and when closing liquidations now, make sure that you are giving advice, perhaps in the context of giving shareholders a choice about whether they want you to close the MVL now or whether they want you to extend it, whether they want you to make a distribution now or whether they want you to delay a distribution. I think those are all decisions that might need to be made. And in terms of the advice that you should have given about the risk of a late claim, if you've got a representation letter from the directors, then you will be relying on that, and the directors will have acknowledged that you're relying on that, and that will give you a measure of protection. You would be advising the company on its need to take and follow tax advice. This is in most liquidators' engagement letters that I have seen. You would need to be telling the directors that there is a risk that HMRC could claim at any time, and that you would usually be duty bound to accept the claim if it's a good one. And even when you're not duty bound to accept it, you would still have an unfettered discretion to accept it. And if you accept it, the cost of it is likely to pass to the members, at least in terms of a reduced distribution to them, and possibly in terms of it being sensible for them to recapitalize the company, or they might have a duty to recapitalize the company. And I've got a reminder on this page as well that it's not just tax that can be an unknown, unexpected claim that comes in. There are other creditors who might make similar claims. Now, every company has a relationship with HMRC. Not every company has landlords, former landlords, has guarantees that they might have forgotten about, or potential environmental liabilities. But those are just some examples of the sorts of issue that can come up as a late claim. So here we are, the summary slide. This is what I'm suggesting is that you ensure that you are following good pre-appointment due diligence procedures with a good investigation checklist that you share with the directors, a letter of representation, you get the letters to sign. You may want a good solid indemnity, but it might be an indemnity that's perhaps a bit more limited than they are at present, and you want to make sure that you are giving appropriate advice to the shareholders, probably in your engagement letter. And then when it comes to closing the liquidation, I think you really should be following the statutory procedure to the T, and that would include a formal rejection of HMRC's claim, even in cases where you have had not a squeak from them. You should be giving them enough time to respond to the notice of proposed distributions, and you should be reminding the shareholders that there is always a risk from HMRC and also other contingent and unliquidated creditors as well. So those are the 4 points that I wanted to cover. If there are any questions, please do ask them now. Let me just see. No questions received as yet, but if you would like to drop me an email afterwards with any questions you've got, I'll be very happy to pick that up. A few dates for your diary. First of all, the next coffee break briefing is on April Fool's Day, and so this will be a slightly more light-hearted one when I'll be talking about legal myths. And by that, a couple of examples. One is every Christmas you will find somebody somewhere will remind you that it is of course illegal to eat mince pies on Christmas Day. Is that true? And another one I'm going to be looking at is a modern legal conspiracy theory, which is the free men on the land. And some of you may have been fortunate enough to have encountered a free man on the land as a litigant in person. And I'll be talking a bit about what they believe, what sort of arguments they're likely to raise, and give you some pointers about how to deal with a freeman on the land if they should pop up defending a piece of litigation that you're bringing. Next date I want to talk to you about is the 18th of May, where David Kirk is organising the Southwestern Conference in Exeter. I'm not involved in that in any way, and I don't think I'm likely to attend it, but it looks like a good range of speakers and some good topics. And if that's your part of the world and a convenient date for you, then drop David an email for further details about how to book and the venue and so on. I will be speaking at the SESCA seminar on the 23rd of May, which is at Denby's Vineyard in Dorking. I'm going to be covering the same topic as I did today, actually, but with a bit more time to spend on it, and of course the opportunity for me to ask questions face to face at that point. Then the 7th of June is the date of our 3rd annual insolvency conference, which is going to be this year in Brockenhurst in the heart of the New Forest. So please make a note of that in your diary, and please do join me for that. And I'll be speaking again at the SESCA conference at Reading University on the 12th and 13th of September, and again at the Denby's SESCA seminar on the 10th of October. So I hope to see many of you on either or both of those dates. A couple of points made. Firstly, pointing out that the 1st of April is a bank holiday. Well, I've been fooled by that one. In that case, I think that we will have an official April Fool's Day on the 8th of April, and we'll have the coffee break briefing then. And I've also had a reminder here that there is the R3 Southern Forum on the 21st of March. So that one is now coming up very soon indeed. So the information about that is on the R3 website. So yes, my apologies for not mentioning that. That's the R3 Southern Forum on the 21st of March. And with that, if there are no further questions, then I will say goodbye and thank you all very much for joining me this morning. And I will see you again in April, if not before. So thank you and goodbye.